Hello, and thank you for choosing the Legacy Lawyers as your source of information. We know this might be a difficult time you are going through, but we are here to educate you and help you through the process. Please stay tuned for our question and answer portion.
Good morning, Erin.
Good morning, David. Enjoying your morning so far?
Yes, ma'am.
Very nice. Okay, so we've been speaking about limited conservatorships.
Mm-hmm.
If a mother is going to establish a limited conservatorship for her child, is there a certain time she should apply for a limited conservatorship?
Okay. That is very fact dependent. So there's sort of the belts and suspenders approach where you're going to make sure there's absolutely no gap in having powers as parent versus having powers as conservator. And what you do is you petition the court and time it in a way. This is generally speaking while the proposed limited conservatee is age 17, and then when you get to your hearing date, your petition will be approved to come into effect on the 18th birthday. So I've seen a lot of parents come in and say, you know, we have a wonderful son or daughter, and we've been making decisions for them. They're somewhat rebellious at this time, and but they need our help. And we want the best for them. And I have a feeling as soon as they turn 18, they might want to join the Merchant Marines and scamper off. And that's going to be a problem for them, as much as we respect that decision. Mm-hmm. So we're going to sort of get ahead of it. And we're going to petition the court. And the court will make their findings and determinations, say this person is in need of a limited conservatorship. And as soon as this child turns 18, you will be the limited conservator, and there will be no break in who gets to make those decisions. I've seen parents with absolutely wonderful children with developmental disabilities. And they come in, and the parents are of substantial age. And they come in and say, you know, the doctors have always been very, very cooperative. But now it's getting to the point where they're kind of getting uncomfortable. And I say, okay, well, that's fair enough. How old is your child? And they'll say 52. And I'll say, okay, well, there's no time like the present. And everything was sort of agreeable and copacetic. Between ages 18 to 52, and now, for whatever reason, the physicians that have had a long-time relationship with the parents now are getting uncomfortable, and the parents now need to be formally appointed to make these decisions. So if I were to sort of go into a machine and go back in time and say, well, your child's about to turn 18, you better get appointed, they may tell me to buzz off. But you can't rely on facts and circumstances as you sit there to determine the urgency or non-urgency of a situation. Because just as many times as I've seen those situations, and they are a few and far between, I've had situations where, okay, well, the child was cooperative up through age 18, and then now the child is now an adult and 24, and is starting to get stir crazy, saying, you know, my parents are, you know, and this is from the child's perspective, you know, okay, well, you know, I have a self-awareness that there is some need for decision-making on my behalf, but I'm 24 now, I'm an adult, I don't like living with my parents anymore, they're getting older, they don't appreciate everything that I appreciate. They don't fully recognize or appreciate my development since age 18. Damn it, I want that red hot Camaro. My life would be so improved if I got that Camaro, and I don't care that it's $35,000. If I got that Camaro, I can get a job and move out, and I'll show them. And you'll see this very often because now this person, this proposed limited conservatee, has been an adult for 6 years. and by their perspective has sort of in their mind demonstrated that they can live independently, even though they've been living at home and they've just been going to, let's just say, a workshop every day by bus. So, and I've seen this quite often. So there is a time in which that happens after age 18 that you start to encounter a lot more rebelliousness and a lot more sort of a psychological shift in which the assistance or the nurturing or the decision making is less appreciated. And it gets to the point where, while at age 18 or 19, the young adult can say, okay, well, my parents have initiated this court action just to keep status quo, just to keep things going just as they were. I'm satisfied. So when the court-appointed attorney or the court's probate investigator interviews me, I'll say, okay, well, they've been doing a good job, and, I'm happy right now as I sit here today, so I don't object. At age 24, or even, age 19, they may say, I really want to move. And then the probate investigator, court-appointed attorney will just ask them, do you want your parents to be your decision maker? And they'll say, absolutely not. And then the court-appointed attorney can say, well, they're there. I appreciate your position, but I'm going to recommend to the court to override your position and appoint a conservator for you. The court-appointed counsel is an advocate. They don't get to make the judgment call. They're not the judge. So what's going to happen is that if there's some sort of disagreement, the parents are going to show up to the court, fully expecting that the court's going to approve their petition. But now that they've waited, and the young adult child says, I don't want a conservatorship, the court-appointed attorney will have no choice but to report to the court, my client doesn't want this conservatorship. Does that mean that the petition just vaporizes? Absolutely not. But what that does mean is that the parents are going to have a trial on their hands, and they're going to have to go to trial or some sort of evidentiary hearing, which will be costly, and demonstrate to the court that a limited conservatorship should be imposed upon the objecting child through evidence. And that can have a gigantic effect in the cost of initiating one. So whenever a conservatorship is appropriate, my suggestion is not to wait, not to rely on the present state of affairs and agreement to persist indefinitely into the future.
Okay, well, thank you very much.
You're welcome.
And if you guys have any additional questions, feel free to email us at smm@thelegacylawyers.com. Have a great day.
Thank you.